We'll see you. All right, good morning. We're going to go ahead and start with the jail cases, but they are not actually on with us. They're on with us, but they don't have anybody there. So as soon as the jail is ready for the Zoom, we'll pick them up. And I'll start with the regular call of the docket. 2024 CR 19604, State versus Ryan Scott Babcock. Mr. Locker.
Yes, Your Honor. I've talked to General Willoughby. We'd like to get a trial date, but we still need the option to settle the alleged victims in the Air Force, and General Willoughby's having difficulty getting a hold of him. And I imagine now that we're in a, whatever they call it, war or whatever, it might be more difficult. Excursion, now that we're in an excursion.
Well, you make those comments and stay out of it. So you're wanting to set it for another status?
General Willoughby would like to get a trial date, but with leave to set.
I don't care. I'm just asking.
On another status then, Your Honor.
Well, I'm not back here until July. So you want to set it for July, but also give him a status date at the beginning of the month? You tell me what you want to do. I don't care.
Just a status date, Your Honor. Just a status date would be fine.
That would be then July the 14th. July 14th. That will be the final status day.
Thank you, Your Honor.
Okay. 2024 CR 19588, State versus Timothy Baxter.
Yeah. I represent Mr. Baxter. I have not seen him this morning. I do know that he lives in Jackson, Tennessee, so maybe just second call him.
All right, it is the final plea day. 2024 CR 19623, State versus Alexander Beecham. So we had reset it for today to be retired after 6 months from September the 9th. He would pay the court costs, have no problem, no charges, no bounty hunting in Cheatham County, and if costs were paid and no new charges, he did not have to appear. According to the docket, he has not paid a single dime. Is that correct?
That's correct.
All right, so we need to put it back on the active docket then.
Yes, sir.
All right, you want to go ahead and sign a trial date? Pardon?
I said we don't need to set a trial date.
All right, we're gonna put it back on the active docket. What that means is I'm gonna set you one more status day, and if you have not resolved your case by an agreement on that day, then I will set it for trial, and you will either go to trial or plead to the end, or you go to sentencing. That would be July 14th. Make sure you stay in touch with your lawyer and let her know that, what the situation is.
Well, from what I was told from my lawyer, she's no longer my lawyer. Because when I asked her about this, she said that when the case got resolved,
she
was no
thinks
longer
that the
my-
case has been resolved, but it's not resolved until you've complied with all of the terms of the
And that was
agreement.
the payment, but I expressed to her that I couldn't even afford to pay it because the only thing that I get is VA disability. And when the deal was brought to me, it was with no cost, and I got surprised with the cost when I
You
came.
need to understand one thing, and that is you're explaining to me the reasons why you haven't complied with the reason, and I'm not hearing those today. This is just for us to determine whether or not you've complied. You haven't complied, so we set it for a final status day on July 14th. As far as our records go, she is still your lawyer. You need to let her know that.
If I pay before the July 14th, I don't have to come for that.
Well, you can talk to the district attorney about it. That's not part of what you were supposed to have paid before today. If you talk to the DA's office, and if they are agreeable to that, then we'll see. You need to be here on July 14th unless it's otherwise agreed.
Okay.
All right, at the jail, let's go ahead and take you up. While we're waiting for the jail, let's go on to the next one. 2023 CR 19378 State versus Fletcher Dale Bowling Jr.
Judge, I don't represent Mr. Bowling in this matter, but I'm familiar with this other stuff. He is in rehab as of last week and was doing very well. So I imagine that is where he's at. I can double check that and make sure, but I think he's still in his rehab.
Do we need to then just set it for the July 14th?
Yes, sir.
Or July 14th. All right, that's the jail. If you'll unmute your device, please.
Yes, Your Honor. This is
Can you hear me okay?
docket number 19434, page 2.
All right, at the jail, who do we have?
Your Honor, this is Timothy Clark, docket number 19434, page 2.
Judge, I represent Mr. Clark. This is the case General Willoughby and I have discussed with you. He had a mental evaluation originally through Dr. Moore. At that point, we, Public Defender's Office, got a private mental health evaluator. We just now got his report back. I've got to get that to General Willoughby. So I think we just need another status day.
Is that correct? July 14th. Mr. Clark, your lawyer is working on your case and he is he's asked to reset it for July 14th so that he can get with the district attorney and with you about it. So we'll come back to you on that day. Thank you.
Your Honor, this is Keisha Short on docket page 8. I don't have a docket number for her.
I can't hear. Oh.
Right. All right, this is 2024-19583. Ms. Short, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, I do.
All right, I'm going to appoint the public defender to here in the courtroom to represent you. Mr. Bond, you wish a formal reading of that affidavit?
Oh, no, sir. We'll waive that and enter plea not guilty.
Plea of not guilty is entered. We'll set it for March.
Well, can we ask her what the status of her Davidson County case is?
Your lawyer is asking Ms. Short what the status is of your Davidson County case.
It's dismissed. I didn't get charged for it. It's dismissed.
March 31st?
All right, March 31st. Your lawyer will be able to talk with you about this case and get you ready for a hearing on March 31st. Thank you.
Thank you.
Well, while we're waiting on the jail, 2026 CR 19853 State versus Charles Ronald Chambliss for arraignment. Come up. Chambliss, you're here to be arraigned on an indictment charging you with theft of property valued between $10,000 and $60,000. It is a Class C felony. You have the right to an attorney. Do you wish to hire a lawyer to represent you?
No.
All right. Do you want a lawyer?
Yeah,
Are you able to hire one?
no.
Raise your right hand. Let's place you under oath.
Yes, ma'am.
We're going to give you an affidavit of your income and expenses for me to have you fill out under oath. And that means everything that needs to be accurate because it'll be perjury if you're lying on that affidavit. I'll come back to you after you filled it out to determine whether or not you qualify to have an appointed attorney. It's not an automatic thing. And if you don't qualify, then Then we'll come back to you. Have a seat. At the jail, what is your name?
Your Honor, this is Austin Howard, docket number 19717, page 4.
Mr. Flanagan is your lawyer, Mr. Flanagan.
Judge, should we go to March 3rd? We're close to getting having an idea.
Your lawyer says he's working on your case and asked for it to be moved to March 31st. And we will put you on the docket with March 31st and let you and your lawyer see if you can resolve it. Thank you.
Thank you. More. Everyone, we're just gonna go over. Your Honor, this is Jerry Moore, docket number 19733, page 6.
All right, Mr. Moore, you are here today. And it's my understanding that Mr. Willoughby, you represent Mr. Moore, and he's charged with second-degree murder, and this is his plea or status date.
That's for plea, Your Honor, if we could have him brought up, because our victim's family
All right.
wants to read a statement.
And I'm standing in for Miss Stephanie Ritchie Mize, Your Honor,
All right,
for real. Thank you.
We're going to bring you up, Mr. Moore, for disposition in your case, so you'll be brought up here into just a little bit, okay?
Yes, sir. He's gonna bring it up. It'll be Parker. Parker next. Parker. Your Honor, this is Jerry Parker, docket number 18767, page 7.
Page 7. All right, Mr. Parker, you are here to be arraigned on the charge of probation violation. You have the right to an attorney to represent you. Do you want a lawyer?
I have one, I've already obtained one,
All right, who is your lawyer?
Margaret Wilkerson.
All right. This affidavit of violation of probation alleges that on or about the May 17th, 2019, you were convicted of misdemeanor reckless endangerment of driving while your license was suspended and sentenced to 11 months and 29 days. And that it's alleged that you have violated the terms of that probation by failing to report to your probation officer since June 18th of 2019. And as a result of that, there was a warrant issued against you on July the 30th of 2019 within the term of your probation. I'll show that you have been arraigned on this charge. We'll enter a plea of not guilty and set you for the March 31st hearing. You need to make sure your lawyer knows that you're set for hearing on March 31st.
Yes, sir.
All right, thank you.
Harry. Harry, right here. Harry. Your Honor, this is Trace Perry, docket number 19849, page 7.
Mr. Perry, you're here to be arraigned on an indictment charging you with evading arrest by vehicle with the risk of death, speeding, driving in opposing traffic lanes, and reckless driving. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender?
Yes,
Public
sir.
defender, and I'm giving them a copy of the indictment against you. You wish to have a formal reading of that indictment?
No, Judge, we'll waive that and plea not guilty.
Plea of not guilty is entered. All right, status for the July 14th. All right, we're going to put you on July 14th for status to see if your lawyer can, after investigation, can work out something by agreement, or if we need to set you a trial date. So your lawyer will be up and talk with you and get you ready. Thank you.
Thank you. May I ask who my lawyer is?
Your lawyer is named your lawyer is named Winston Vaughn. I have two men in my courtroom who both have really nice beards. One is a public defender, the other is the district attorney. So I will inevitably confuse the two of them. So anyway, your lawyer is named Winston Vaughn. He will be up to talk with you.
Okay, thank you very much, sir.
Your Honor, this is Kenneth Smith, docket number 19845, page 8.
All right,
How you
Mr.
doing,
Smith?
John?
You are here to be arraigned on an indictment charging you with making a reckless, threatening act of mass violence on school property. There are 3 counts of that indictment. You have the right to an attorney. Do you wish to have a lawyer represent you?
A lawyer?
A lawyer. Do you want a lawyer?
I thought, he was supposed to been here.
It's Tim.
You,
It's Tim's.
Tim Richter. All right. We'll hand a copy of the indictment to Mr. Winston Baum, with the public defender is here. Mr. Richter is the other lawyer with the public defender. So we'll appoint the public defender's office to represent you. And you wish a formal reading of that?
Do not judge or waive it or plead not guilty.
The plea of not guilty is entered. General?
That's general savings.
So that will be, what day do you want to put it on?
I think they've been doing Wallace's status thing. It should be 14th of April. I'll check you. Or do you want to?
No, we're going to put you on April the 14th and
Okay,
let your lawyer work on your case, and then we'll have a different judge, but they'll take care of looking at your case on that time.
a different judge, sir?
Pardon?
A different judge?
Yes.
Okay,
Thank you.
okay.
Session.
Yes, and I'm gonna stand that. Bang. There's nobody in court. Yeah. Your Honor, this is Jacob Spandon, docket number 19844, page 8.
Mr. Spann, you're here to be arraigned on a charge of driving while your license is revoked and DUI, 4th offense, and theft of property. You have the right to a lawyer. Do you wish to have a lawyer?
Yes, sir.
Public defender?
We'll waive formal reading.
Public defender is here and has been appointed to represent you. Plea of not guilty is entered. General?
Also need to track the actual date.
That was April what? April 14th.
General Stevens.
Okay. Your lawyer's being given a copy of the charges, and we've set you next month on April 14th for your lawyer to try to talk with the district attorney or get you set for a trial. Thank you.
Stewart. Stewart. Your Honor, this is Landry Stewart, docket number 19825, page 9. Yes.
Mr. Smith, you're here to be arraigned on an indictment charging you with theft of property between $10,000 and $60,000, possession of a Schedule I drug with intent to deliver, and coercion of a witness. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes.
I'm sorry, you froze for a second. Do you want a lawyer?
Yes, I would like a lawyer, sir.
All right. We're going to appoint the public defender who's here in the courtroom to represent you.
We'll waive formal reading and plea not guilty.
Plea of not guilty is entered.
4/14.
This is a superseding indictment. I didn't notice that, but he's already set for June the 2nd.
We'll just leave
So
it.
we'll leave him set for June 2nd. Your lawyer's given a copy of that and you remain set for June the 2nd.
Can you tell me who my a lawyer is?
Yeah, we've given you the public defender's office. Mr. Richter with the public defender is here in the courtroom. He's been given a copy of the new indictment. It is called a superseding indictment, which means that they have gone back to the grand jury and gotten a new indictment charging you with the same offenses, but some difference in the indictment itself. But your lawyer has a copy of it. He'll explain it to you more fully. So Mr. Richter will be up to talk with you and explain all of this to you, okay?
Okay,
All right.
Watson. Your Honor, this is David Watson, docket number 19848, it's 19857, page 9 and 10.
Watson, you're here to be arraigned on an indictment charging you with theft and assault on a police officer. There are two different indictments. You have the right to an attorney. Do you wish to have a lawyer represent you?
yes,
I'm going to appoint the public defender who's here in the courtroom. I'm handing him a copy of both of the indictments.
Judge, I'll arraign him still. We'll wait for him reading in her plea not guilty, but we had a conflict with this in sessions. I believe Sonny Stevens.
Who was appointed? Sonny Stevens. All right, Mr. Watson, because the public defender has a conflict in your case, we're going to reappoint the Sonny Stevens to represent you. Mr. Vaughn with the public defender's office has waived the formal reading of the indictment. The plea of not guilty is entered. General? All right, so that would be the April 14th day. Your lawyer will be advised that she's been reappointed on your case. We set you next month on April the 14th for you to see whether or not y'all can work out an agreement or we need to set a trial date.
okay,
All right. Margaret Brady Wilson. We'll appoint her then if she was the one in the general session.
Your Honor, everybody else on my list is bring ups.
All right, thank you.
Thank you.
All right, we'll run back to the regular call of the docket then. On page 2, 2023 CR 19522, State versus Dawson Tanner Colbert.
Judge, I represent Mr. Colbert. He is here on a violation of probation stemming from a drug screen that was tested positive for marijuana. I spoke to General Willoughby. Mr. Colbert is going to admit that he's in violation, be reinstated to probation. Obviously, he's out on bond, but he will need to complete an MRT class.
Mr. Colbert, you raise your right hand. Let's place you under oath.
Yes,
State your full name for the record.
Dawson Tanner Colbert.
So you want to serve 2 years in prison?
No, Your Honor.
Well, you use marijuana. That's what pretty much you're saying is that you want to use drugs while you're on probation. You're going to know you're going to be tested for them. Then that means you particularly want to go into prison and serve 2 years.
At that time, I was off my psych meds, and I am currently getting back on my psych meds. I have appointment actually tomorrow with Centerstone to get back on my medicine and everything.
Well, I understand that may be the situation. What I want you to understand is the significance of even a positive drug screen from this point forward means that you're going to go to prison. So you got to make a decision. I understand you may have some medical issues and you're dealing with them, so I'm happy to hear that. All right, you understand that you're charged with violation of probation. Do you understand that you would have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, Your Honor.
You understand that if we had that hearing, you would have the right to have a lawyer and have one appointed as we've done with a public defender.
Yes, Your Honor.
Do you understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
You understand that by pleading guilty, you're waiving your right to a hearing and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, Your Honor.
Do you understand that's going to reinstate you to probation, but require you to, in addition to your regular probation requirements, to complete this class that you're talking about?
Yes, Your Honor.
You understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead guilty according to this
Yes, Your
agreement
Honor.
and waive your right to a hearing and to an appeal?
Yes, Your Honor.
And upon your plea of guilty, I find you guilty in order that you be revoked to serve your sentence. But by agreement with the state, I'll reinstate you to probation with the additional requirement that you complete this MRT class.
And just as a housekeeping, so he actually expires tomorrow, so he'll need to be extended.
It'll be extended for a period of 1 year.
However long it takes him to get this class. effectively.
Well, we'll extend him for 1 year. I think 1 year is the maximum I can extend him, so.
Yeah, I believe so.
Maybe two.
I don't know that that's the interest of.
Just want to extend it long, complete these requirements, however long it may be.
We're gonna extend you for a year, and if you get the class completed and the state agrees, then you can come back in and have your probation terminated.
Yes, Your Honor.
Can we just give him a May court date then?
That's fine.
Will you give me all the information for the case guy?
May 25th, May 26th. That'll be the date that you just stay in touch with your lawyer and let them know you've completed the class. And you can come back in on that day and have your probation terminated if you've done everything you're supposed to do.
Yes, Your Honor.
All right.
I'll get it done as soon as I get the information on the
All right.
class.
Good luck to you.
Yes, sir.
2025 CR 19793, State versus Cheryl L. Doherty. Mr. Lockhart,
I have not seen Andrew Robert.
Andrew Lockhart.
We have discussed the case. He had an offer extended. Thanks for getting completed, but
I'll put it on the second call. Twenty 2025 CR 19770, State versus Andrew Eugene Fox.
Judge, I represent Mr. Fox. He just got here. He's got an offer. I haven't spoken with him. If I can just second call him.
Second call. 2025 CR 19683, State versus Terralandus Fritz.
believe, Mr.
Fritz, come on up.
if we could put this on the 31st, Your Honor, I've done my homework on it as far as the issue with the diversion, but I just need to have a conversation with Mr. Walwin.
I'm standing in for Mr. Wall and he's out of the country. I don't know whether it's ice related or not, so he should be back on March 31st.
With or without a
All right.
mask.
March 31st. 2025 CR 19797, State versus Jeremy Greenwood. Mr. Lockhart, Jake Lockhart.
Mr. Greenwood. I've got an offer, but I haven't heard from him in a while, Your Honor.
You want me to pass it for second call, let you see if you can, before I revoke his bond, or do you want to go ahead and revoke his bond?
I mean, I'm not gonna say I want to revoke his bond, but I tell the
I'm
court,
not asking.
I'm not confident that I can get a hold of him, so.
All right, we have a bond. All right, there'll be a conditional forfeiture of his bond in the amount of $20,000. Our facia to the bonding company. The capias for the arrest of the defendant, and we need a date 6 months down the road, which will put us into September. September the 8th will be final forfeiture. New bond will be $100,000. Twenty CR 19041, State versus Roy Kenneth Harris. Mr. Harris, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer?
No.
You don't want a lawyer, okay. This was basically here because you had not paid your court costs, which is docket number 19041, and you owe $1,120.50. Why haven't you paid that?
Well, I've been having trouble with transportation and getting to work and things like that, and I've been helping my mother. She's elderly. I did file a motion to see the judge on April 14th for a reduction in court costs due to all that.
So is it set for April 14th? All right, we'll pass it. Well, first of all, let me arraign you. This alleges that you were placed on probation on or about March 11th, 2024 for the offense of evading arrest, reckless endangerment for a period of 2 years, and that you have violated your probation by failing to pay your court cost balance of $1,120.50. We'll show that you've been arraigned in a plea of not guilty, and we'll set it for that April 14th day for you to have the hearing in front of a different judge about whether or not to relieve you from those obligations. All right, thank you.
Thank you.
Twenty 2025-019-716, State versus Dallas, Paul Hatfield, Mr. King.
Yes, Your Honor, that is from Please.
All right.
Still now, it's present. So.
All right, I've been handed a document indicating that Mr. Hatfield is going to be entering a plea of guilty to attempted child abuse, neglect, or endangerment. It would be a Class E felony, and he'd receive a sentence of 2 years to the State Department of Corrections as a range 1 offender, just with a release eligibility of 30%. He would serve that on supervised probation, complete a parenting class. This would be concurrent to 2024 A640 Davidson County, and his ankle monitor would be relieved, and he would be required to complete an 8-hour anger management class. Does that cover everything?
Yes, it does, Your Honor.
All right, Mr. Hatfield, raise your right hand. Let's place you under oath.
I do.
State your full name for the record.
Dallas Paul Hatfield.
Mr. Hatfield, you're here today charged with, actually with child abuse and neglect, but I think it's been amended to attempted child abuse, neglect, or endangerment. But have you seen or been shown a copy of those charges, talked them over with Mr. King, you and he discussed the range of punishment you're facing as well as any possible defenses you might have?
Yes.
Well, it's indicated that you want to enter a plea of guilty. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, Your Honor.
Do you understand if we had that trial, you would have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes.
Do you understand if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
Do you understand that if you went to trial, you and Mr. King could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes.
Do you understand that trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, Your Honor.
Do you understand that's going to result in a conviction? And that conviction will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, Your Honor.
Do you understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, Your Honor.
Do you understand if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determined that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, Your Honor.
Do you understand I can't accept your plea unless I'm satisfied you're guilty and there are facts to support it?
Yes, Your Honor.
Then are you in fact guilty of this charge of child endangerment?
Yes, Your Honor.
And tell me what happened.
Well, I've had my stepson, or not my stepson, the child for a while, and he was opening the door, and I told him multiple times not to, and I whooped his butt on the side of his cheek. He was wearing a pull-up, and about an hour later, when he was playing, he bent over to pick up a toy, and I seen that it left a mark.
All right. General Willoughby, you want to add anything to that?
That's pretty much it.
Are you satisfied with your attorney's services?
Yes, Your Honor.
Do you believe that Mr. King has done a good job of representing you competently?
Yes, Your Honor.
Mr. King, you know of any reason he should not enter this plea? Any reason he should not enter this plea?
No, Your Honor.
Then Dallas Paul Hatfield in docket number 2025-019-716 upon your plea to the amended charge of attempted child abuse, I find you guilty, sentence you to 2 years in Tennessee Department of Corrections as a range 1 offender and will be suspended to supervised probation. As a condition of your probation, you must complete a parenting course and an 8-hour anger management course. And this will be served concurrently to your Davidson County case. You may have the ankle monitor removed immediately. So you'll need to see the probation department.
Thank you, Judge.
Mr. Willoughby?
Yes, Your Honor.
Thank you. Docket number 2026 CR 19843, State versus John Anthony Hodge. Can you represent him? Right. I'll hand you a copy of this indictment. Do you wish a formal reading of that indictment?
John Anthony Hodge, 19843, pleads not guilty in ways formal reading of the indictment.
Plaintiff not guilty is entered. General, on a date?
It'd be General Hodlin's case, if we can track it with me on 14th of July.
April 14th. July 14th, sorry. July 14th.
So
That will be for status, July 14th at 9 a.m.
yes, sir. Thank you.
2025 CR 197249, State versus Milton Kirk Hunt. So that's Mr. Vandervoort's case. We heard from Mr. Vandervoort.
I have, Your Honor, we talked about passing that to the 31st. I don't know, actually, I think you texted me, but don't know if he's planning on being here, but that's what we've had in our community.
All right, if you've talked with him and the agreement was to pass it to the 31st, we'll put it, then that will be his final plea day.
Mr. Hunt here,
2025 CR 19744, State versus Messiah Aiton Israel. Good morning.
Ms. Crabtree and I are doing that case and we filed some motions. Hey, now I'll meet you in real life. And she is gonna answer those motions, which will get away with the, do away with the bill of particulars request. And then we had a motion to sever, which the state has agreed to.
We're set for this afternoon at 1:30, I think.
Yes, but we've resolved it all and we don't want to lose the trial date. She hadn't given me the answer yet, but I've talked to General Sylvia and I think it's going to encompass everything I need to know. And so subject to your honor's approval, if we could agree to that and leave it on the same trial date, please.
You two have agreed on the motions and we'll leave it set for the trial date on March 25th.
Thank you, your honor.
Thank you.
And can I address a few
Yes,
more?
of course. I was sorry to hear about your family situation.
Thank you very much. I have Rebecca Jobert on the left. You can go, I'm sorry. You can. Rebecca Jobert. The general and I are requesting to move that to the end of March for that sentencing hearing.
So you want to put it on March 31st?
Please, sir.
All right. What was the last name again?
Jobert, Joubert.
Very last page of the
That at
doc.
1:30, and that is correct.
All right, we'll move it to March 31st by agreement.
And one last question, Your Honor. Mr. Harrison is on for a sentencing hearing. That's not until 1:30. We've agreed just to put him on probation. We don't want to have a hearing on that misdemeanor.
What if the judge doesn't agree?
Oh, well, yeah, you can change your mind, but I want to get another body to do that for me, just to do that at 1:30.
or you can grant a motion for new trial and do it all over.
Oh, no. Well, it was kind of an entertaining trial. It was a free-for-all in the neighborhood.
I remember.
Yes, yes.
So is there any reason to wait till 1:30 or do you have victims coming in?
No, Your Honor.
You do not? Okay, let me see if Mr. Harrison can come in early. If I can't get him here before 1:30, if you'll.
You need to leave, and we'll just have somebody stand in for you, even if it's Mr. Vaughn.
I'm fine with whatever. So as long as
So you want to leave it at 1:30 to dispose?
Yes, and then
Mr.
that,
Vaughn, we're gonna let you stand in for her.
just
But
because,
Mr. Willoughby knows what the agreement is, correct?
Yes.
All right. It'll just be an announcement.
yeah, since we're gonna resolve it, I'd rather do that than just keep passing it along. Thank you.
Thank you. All right. Moving to page 5 of the docket, 2026 CR 19851, State versus Marvin Wayne Jock Jr. Mr. Jock, you're here to be arraigned on an indictment charging you with driving under the influence. You have the right to an attorney. Do you wish to have a lawyer represent you?
I have one.
Who is your lawyer?
You representing.
Raise your right hand. Just because you had a lawyer appointed in the lower court doesn't mean you're automatically entitled to one up here. You're only entitled to an attorney to be appointed for you if you have no available means to hire one of your own. That requires me to have you placed under oath and have you fill out an affidavit of your income and expenses for me to determine whether you're classified as what we call indigent, meaning that you have no ability to hire a lawyer. So we're going to give you a form to fill out. Once you fill it out, you will be signing it. And when you sign it, you're making an oath that is information is true and correct. Lying under that, if you misrepresent it or you lie under it, that's perjury. So you need to make sure it's accurate. Fill it out and then hand it to one of the bailiffs and we'll come back to you. Thank you.
Thank you.
Twenty 19710, State versus Jonathan Kane Krantz.
Judge, represent Mr. France. Apparently he's gonna be here in 5 minutes. 45?
I'm sorry, what is this?
Can we second call him, Judge? He's on his way.
Second call. 2022 Sierra 19259, State versus Sarah Lamb. This was to review on payments if paid in full. She did not have to appear and I showed that she has paid in full.
She has paid in full?
All right, so we will show it's dismissed according to that agreement. Twenty 19337, State versus Richard D. Leester.
Judge, I represent Mr. Leester. He was on, I don't know if it wasn't a furlough, I don't believe, but he was in a rehab. It's come to my attention that he has picked up new charges apparently in Gallatin, according to his probation officer. I don't know. He was supposed to show up in January, but the ice storm hit, and that's why he's on March. So I doubt he knew to be here, but he also probably might not have shown up anyway. But
Do we have a bond on him?
Take that, sir, as a bond.
Well, I mean, obviously, if he's in rehab, but he's picked up new charges while he's been in rehab, then it's not taking very well, I would assume.
that's fair,
So-
Judge.
But does he
Got
have a bond? To be a conditional forfeiture of the bond in the amount of $12,000, citation of the bonding company set for that September date for final forfeiture. Capious for the defendant's arrest, hold for a hearing without bond. Twenty 19750, State versus Jason Christopher Mangum.
Mr. Mangum is also present. I've spoken with General Willoughby. We'd like one more status date if we could get your July date, please.
All right, this was set for final plea today, but it's agreed that it would be reset.
Yes, Your Honor. We've had some trouble getting a hold of a particular person, so, and I say we, her.
July
mean me.
14th.
He means me. I've had some trouble getting in touch with a particular person I need to finish this up.
All right, well, we're gonna give you one more chance to settle it, so if we don't
Thank you.
settle it, if it's not agreed upon, and I don't care one way or the other, but if it's not agreed upon on July 14th, we'll set it for trial. once you're past that last plea day, that means you go to trial or you plead to the indictment and go to sentencing. So make sure you stay in touch with your lawyer, let her help you through this process and make sure that you follow her advice. Okay?
Yes, sir.
All right. Thank
Your
you.
Honor, it is in no way Mr. Mangum's fault. He's not the person I'm trying to get in touch with, just so the
I
court
don't
is
believe
aware.
It is his fault, but I'm
Thank you.
giving him a piece of advice to listen to his lawyer, so.
Thank you.
All right. 2015 CR 19722 State versus Braxton Wade Milam.
This has been set for trial, unset for trial, that the offer is to dismiss it upon payment of restitution. You know anything about it?
That's General Hodder. He hasn't said anything. Is he even here?
I don't know where Mr. Mullin is. He's
His client.
I don't know where he is.
Braxton Wade Milam.
But he's been here every other time. It's just a matter of restitution to be paid. It's gonna be dismissed, but he doesn't have any money. And I can vouch that he doesn't have any money because he hadn't given me any money, but,
I thought you were gonna say he doesn't have any money. 'Cause
he's
he gave it all to
he's
you.
a friend of my wife's. We put it on March 31st and we'll get it resolved.
We'll give him one more trial, one more chance.
Okay.
March 31st.
Means I'll have.
Make sure he's here.
Judge, the only other matter I have is Sonia Terry. It's for an arraignment.
All right. Last name is
Terry,
Terry.
T-E-R-Y.
On page 9.
It's a DUI case. She came by the office Sunday and executed a waiver of her appearance. And I don't know what I did with it. So what I want to do is I want to waive filing the waiver until I can send it over later today.
How about we just give you an extension of 30 days to file your written waiver of arraignment,
I may not find it, but
whatever you want to do.
I'll send it over today. It's at the office. We know Mr. Stevens is.
All right, we'll show that Mr. Flanagan is the attorney. We're going to show he's waived the formal reading of the indictment, enter a plea if not guilty. Set it for that April date, April 14th.
Thank you, Judge. That's all I have.
Good luck with your rehab though, Mr. Flanagan. 2025 CR 190808 State versus Aaron Patrick Northcutt. Northcutt, do you have a lawyer?
Yeah.
Pointing back there behind, is the television your lawyer?
No, sir. Locker.
Oh. All right, Mr. Lockhart, you represent Mr. Northcutt on especially aggravated stalking.
Yes, Your Honor.
And it was set for status today, the last plea, and it's set for trial May 27th. Any disposition that we need to note?
Don't believe Your Honor. General, to the second.
Mr. Lockhart, I had been with the manager, we made one more date, offered Mr. Lockhart.
Well, this is not set for trial in front of me. It's set in front of a different judge, but it. So
There
you
we
got a
go.
conflict because your cousin is the judge that set on the May date. So let's go ahead and put it on March 31st. Is that sufficient time for you to try to work out an agreement?
Yes, Your Honor.
We'll know at that time whether or not it's going to be settled or it's going to have to be set for trial. And if it's going to have to be set for trial, we can set it on one of my days.
Yeah.
You. All right, let's move to page 7, 2025 CR 19820 State versus Rachel L. Parker.
Yes,
Hello, Ms. Waynick. All right, you represent Ms. Parker there, correct?
I do.
She has filed a waiver of arraignment. I'll hand you the indictment.
Thank you.
Will show that there's an enter a plea of not guilty. Do you want a formal reading of that?
No, we waive that, please.
All right. Plea of not guilty is entered. What day do you want to set this in general?
I believe this is, John Stevens' case.
John Stevens' case, then that would be April 14th. April 14th.
April 14th. Okay, thank you.
2026 CR 19858, State versus Benjamin Parker Richardson.
Your Honor, he called. Was told this morning that he called the clerk's office and said that, he was sick and they told him he needed to be here. So we may second call that. He does not have counsel at this point.
Okay. Put it on a second call. If he comes in, give him a mask. If Mr. Benjamin Parker Richardson comes into the courtroom, I want him in a mask if he says he's sick, so. All right, 2026 CR 19850, State versus Tiffany M. Rowe. Tiffany Rowe for arraignment. Charged with criminal impersonation, identity theft, and resisting stop and arrest. Right, Tiffany Rowe, failure to appear, there'll be a conditional forfeiture of the bond. The certification of the bonding company set for final forfeiture on that September date. Capias for the defendant, new bond will be $50,000. Yes. Yeah, we had it earlier something on here. What's Andrew Locker should come up. You keep, stand as far away from me as you can. My understanding is you've been battling the flu. What case do you have?
Cheryl Doherty. That's going to be for plea, Judge. If we can just reset it for one more day. I've got a TBI background check we're trying to run. She's also in Michigan and she's elderly. Is it possible to do her plea by Zoom? If not, I'll certainly arrange for her to be here.
Cheryl Doherty is aggravated cruelty to animals and she lives in Michigan.
Yes, Your Honor.
State have any opposition to doing it by? In fact, we can do both of you by Zoom if you're still ill, but you want to put it on the 31st?
That'll work, Judge. I would hope that I will
March
not still be
31st.
sick by then.
Show that the defendant and the lawyer will come in by Zoom. Hopefully you'll feel better.
Thank you, Judge.
We can, if you like.
Judge, Mr. Lockard, I'll stay a couple feet away from Mr. Lockard, but Mr. Lockard and I have a co-defendant, or we are both representing Cherie Weston, who appears on Your Honor's docket on 4 cases. The public defender had a conflict based on witness in the burglary case. I'm sad to say, Miss Weston, this case has been going on a long time. Miss Weston went all the way through the Hope Center, was flourishing, worked at the Hope Center, was counseling others. I have lost touch with her and I don't know what to do at this point. I've reached out to Hope Center and their human resources to find out she was working for Hope Center. The phone number I have is dead. I've tried through Facebook messaging. So I don't really know at this point what to do.
The only thing I can, this is her plea day, so the only thing I can do is issue a capias for her arrest or revoke her bond. If there's some reason why, legitimate reason why she failed to appear, then we can reconsider that
And I did check and she's not in Metro's custody, so that would be the only place I would.
You represent her as well?
I do, Your Honor.
Okay.
I've tried to text her and send her some letters and I've also not.
I'm gonna go ahead and, since this is the case, we'll issue a conditional forfeiture of her bond for failure to appear on her plea day. Sorry, facial, what is her total bond right now? All right, there'll be a capias issue for the arrest. New bond will be $100,000, double what she is presently under. And we'll set it for the September certification of the bonding company set for final forfeiture on that September date.
Thank you, Judge.
And again, if you find out something legitimate that she's not here for some reason that is excusable, we'll consider setting that aside.
Thank you,
All right,
Judge.
Thank you.
Thank you, Judge.
Will be double whatever current bond is, so it's 200,000 if it's 100.
Apparently she's in potentially in custody of Sumner County.
Sumner County. Ah, okay. Well, maybe it does, Judge, I will track that down this afternoon.
We dealt with Tiffany Rowe and took a conditional forfeiture of a bond. Then we moved to page 8, 2025 CR 19773, State versus Jack Howard Sanders.
Judge, I represent Mr. Sanders. It started out in sessions as Mr. Richter's case, and then as it got up here, it is now mine and tracking with General Sylvie. I've not been in contact with Mr. Sanders, mostly due to my fault and my understanding that it was not mine. So I need to get with him if we just have another status thing. July, please.
I'm okay with.
July, do we have a July date?
All right, July 14th will be the final plea day. Twenty 26 CR 19854, State versus Rebecca K. Sipe. Motion. Ms. Sipe, she's here for arraignment, is that correct? Ms. Sipe, you're here to be arraigned on an indictment charging you with 17 counts of animal cruelty. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes.
Are you able to hire a lawyer? Raise your right hand. Let me place you on the.
Yes. Your Honor, I have an attorney to this point, but I would really like to request someone else because she is giving me really bad advice.
Who was your attorney?
Lindsay York.
Lindsay
Lindsay York represented her in sessions. There was a preliminary hearing. There's a companion motion for a bond to surrender these animals. This is Ms. Schultz. She's here on behalf of ARC as well. ARC is the Animal Rescue.
Animal Rescue Corps, we're the statutory designee standing
Where are the animals right now?
in ARC's custody.
But they haven't been formally surrendered because we haven't had the bond hearing, I believe, Judge. What is that? Yes. Definitely.
All right, so we have 17 counts of animal cruelty, and we have the Animal Rescue Corps that is joined with a consolidation order out of General Sessions Court that consolidated the civil case with the criminal case.
Correct.
And what I'm understanding is now the ARC, of which I'll use for short, is requesting that there be a forfeiture of the animals, of the custody of the animals into, is that what I'm understanding?
My name is Jessica Schultz, Your Honor, for my first time in your court. It's an honor. So we are not requesting forfeiture. What we're requesting is a security bond to be posted by Ms. Sipe to care for the animals that has been incurred. Today is 215 days since we've had custody. And so our request is for a security bond for Ms. Sipe to post to maintain the animals' cost of care.
And if she is unable to maintain those animals because she just indicated, although I've not yet placed her under oath, that she can't afford a lawyer, much less being able to afford to post a bond. So what happens from the ARC's position if in fact she can't post a security bond?
Yes, Your Honor. So there was a motion filed in the General Sessions Court regarding the indigency concern, which we never had heard. I did put our opposition of that request. And so the statute is very clear that it is for the defendant's responsibility to cover the costs of care. And if she fails to, then that's an abandonment. So essentially her indigency request is essentially a constructive abandonment, meaning that she cannot afford to take care of these animals. And
What
so
kind of
therefore
animals are
that
we
is an
talking about?
abandonment.
What are the animals?
So there are 11 exotic birds, 2 dogs, 3 chickens, and 1 miniature horse.
And if, let's assume for the sake of our discussion that she is not able to post that security bond based on her indigent status, then what becomes with those animals? Pardon? Well, I'm asking her, not you, but.
Your Honor, yes, the statute is clear that if she fails to post the bond within 10 days, then the animals are deemed abandoned, and it is then ARC's responsibility to find new homes for these animals and do what is best for their best interest, as they are victims under the statute.
All right, and now I have been handed a copy of a notice of filing that Ms. Sipe has filed, where, if I'm understanding, she's asking for a motion for supervised visitation with the animals and preservation of evidence. Let's do this. In view of the fact that I'm going to have to appoint her an attorney, I need to address that issue first by letting her file her affidavit. That affidavit will be under oath, and it will help us to determine whether or not she has the ability to post a bond. And that will perhaps answer the question. But if you'll give us a few minutes to deal with that, then we'll go from there, okay?
Okay.
Ms. Sipe, I think I had asked you to raise your right hand. Did we place you under?
Yes.
Then if you're under oath, I'm going to have you fill out an affidavit so that we can determine whether or not you have the ability to hire a lawyer, or whether or not you're indigent. And if you'll just have a seat, fill that out, and just hand it to one of the bailiffs, I'll come back to you, okay? Here, let me have it and come back to it. I'm gonna print it. Right. 2026 CR 19861 State versus Joe Stamps Jr.
Morning, Your Honor.
Good morning.
This is Stamps.
Right. He is charged here with aggravated stalking, harassment, and stalking. And then a second indictment charges him with another count of stalking. I will hand you a copy of the indictment.
Yes, Your Honor.
You want me to read those in open
Oh, no,
court?
Your Honor, waive the reading and plead not guilty at this time.
Show that the defendant has entered a plea of not guilty. General, what day are we setting?
It's mine, yes.
July 14th? July 14th will be for status, so that we can determine whether or not the matter can be resolved by an agreement, or whether or not it needs to have a trial date assigned. That'll allow for discovery and negotiations. July 14th.
Your Honor, if I may, also, my client lives in Florida. If the court would approve and if the state is okay with it, would he be able to attend this hearing via Zoom?
If state has no opposition just for status, I'll agree to that, but
I'm okay with just for status, Your Honor.
just for status, he can come in on Zoom, but it'll be your responsibility to make sure he has the Zoom link.
Now, if we do have a plea agreement, he'll need to appear in
You'll need to
person.
be, if it's by an agreement, a plea agreement, you'll need to appear in person, so.
Understand, Your Honor.
All right, thank you. July
Thank you, Your
14th.
Honor. Have a good rest of your morning.
Same to you. Twenty 1963 State versus Gage Waddell. That was to be dismissed if he had paid the fines and costs or the court costs that's been paid in full, so the case is dismissed. Moving to page 10, 2025 CR 19795, State versus Billy Michael Williams. Williams, do you have a lawyer?
Jake.
All right. This was set for status today.
Yes, Your Honors. General Willoughby's case, we will be entering a plea in this case, so I don't know what date. When do you want to set it?
Any reason we can't do it today?
I don't know if General's,
Well, because, a text message yesterday talked about it, so we haven't fully discussed it here.
All right, repeat that now. So you want to set it, when do you want to set it?
is the 31st on?
Yes.
That'd be fine.
I'm sorry, the 31st?
Yes, Your Honor.
Okay. March 31st.
We'll see.
All right, Mr. Lockard, 2023 CR 19390, State versus Tanyan E. Willis.
Yeah, he's in jail. Metro. He's in jail in Metro. And I didn't find out. I know it wasn't outside 10 days before this court date. So I don't really need him here today.
State just wants a trial date.
All right, so you want to set a trial date? Let's go ahead and set him a trial date. What day do you have in mind, General? July what?
15. Yeah, there's a portion with the locker, we can get between them.
15th is fine.
July 15th? All right, set for trial July 15th.
And since he is in jail, is any leave to settle or was this a no settle case?
I don't know, Mr. Willis has been very, unreceptive of my generous offer.
Would have set for trial that day.
All right, set for trial July 15th. April 14th, is that what you want? Or July 14th? July 14th will be the final status.
Thank you.
Yes.
Yeah, I don't know what he's getting at. Certainly, Mr. Violations.
2025 CR 19783 State versus Maurice E. Wilson.
You set this for the 31st, and then at that point, we'll see where we stand.
And on that point, what?
For status, please.
All right, March 31st for the final status. All right,
Thank you, Your Honor.
2017 CR 18142 State versus Raleigh S. Conquest.
Judge, I believe he's still at large.
All right, we've reached the at-large docket, so we'll run through them all just to be on the record. 2025 CR 19762 State versus Michael W. Cook at large. 2022 CR 19276 State versus Dylan James Decker at large. 2021 CR 19111 State versus Joel Dickerson at large. 2015 CR 17594 DeCarlos Fentress at large. Any of these that we know anything about, interrupt me. Let me know. 2022 CR 19285 State versus Jessica Gomez at large. 2024 CR 19549 Jorge Gonzalez Barragan at large. 2021 CR 19114 State versus Damon Greenlee at large. 2020 CR 19041 State versus Roy Kenneth Harris at large. I'm sorry. He is? Is Roy Kenneth Harris? Is he in custody? Oh, okay. April. All right, we'll put him up to April 14th. Thank you. 2021 CR 19217 State versus Mary Johnson at large. 2024 CR 19593 State versus Austin M. Lindsay at large. 2025 CR 19719 State versus Don McLean. Is that the guy who did the song? Don McLean. Don McLean, American Pie. No. What I thought he was dead. At large. 2021 CR 19069 State versus Johnny W. McDonald at large. 2024 CR 19594 State versus Christopher Dale Meese at large. 2023 CR 19385 State versus Tatum Bradford Moss at large. 2022 CR 19314 State versus Robert A. Perry at large. 2022 CR 19268 Brian Rubenstoff at large. 2013 CR 16885 John Shippers at large. 2023 CR 19460 State versus Nicholas Antonio Shelton at large. 2022 CR 19292 Raymond Daniel Skipworth at large. 2019 CR 18919 Trevante D. Smelly at large. 2023 CR 19383 Deshaun Stone at large. 2017 CR 18299 Aubrey N. Whitworth at large. 2012 CR 16727 Destin B. Wigginton at large. 2020 CR 19010 Mikey M. Womack, or Mickey M. E. Womack at large. 2023-019-477, Edgar T. Harrison. That's the case that we have for 130 for sentencing. Charles Chambliss. Chambliss, you are filing an affidavit here that says you have no income whatsoever. Is that correct?
Yes, sir.
How are you able to live if you have no income?
I'm living with my sister at the moment. I fell
Put
about,
that microphone towards you. Pull that microphone. There you go.
I live with my sister at the moment. I fell about 14 months ago and severely broke my ankle. The bone came out the side. It was pretty nasty, but I haven't been able to work since.
So is all of the information in your affidavit true and correct?
Yes, sir.
All right, I find he is indigent and will appoint the public defender to represent Mr. Chambliss.
We will wait for formal reading, Judge.
Plead not guilty is entered. General, what day?
7/14, you're on Dundee.
July 14th. Your responsibility to stay in touch with your lawyer, okay?
Yes, sir.
Bunch of cases.
Marvin Jock.
Can I have a conversation in the back of the courtroom? Please take it out in the hallway.
So you make $28 an hour according to your affidavit,
Yes, sir.
and for that $28 an hour, that equates to some $1,120 a week, which equates to some $4,000 or so dollars a month in income. What was your taxable income last year?
I'm not sure.
Pardon?
I said, I'm not sure. I haven't filed my taxes from last year.
Well, I find you're not indigent making that kind of money, so I will decline your request for an appointed attorney. What day are we setting this? General, if we're setting Mr. Jock off, we're setting Mr. Jock off for him to hire a lawyer. When do you want to have it set?
It's General Stevens, it should be in April.
All right, we'll set it for April 14th. This is an indictment charging you with DUI first offense. States that he's not eligible for appointed counsel, so let me hand you a copy of that indictment. But I'm gonna, yes, you can waive the formal reading of the indictment, but let's go ahead and give him. All right, making $28 an hour, I do not find that you're indigent, therefore you're gonna have to marshal your assets to hire a lawyer.
Okay.
On April the 14th, you come back in and let the judge know whether or not you hired one, okay?
Yes, sir. Thank you.
Thank you. Rebecca Sipe. Mr. Vaughn,
Yes.
Ms. Sipe has an income only of disability, $1,371 a month. Does your office have any conflict that you know of?
We did have All was, but that would be one.
Are we doing the forfeiture today?
I'm sorry.
Are we doing the forfeiture today?
We're first of all trying to find you a lawyer.
Okay, because I need a lawyer for that because we're contesting it.
Do you know if any of the other attorneys locally have a conflict?
Probably. Sonny should. I don't know.
What about clerks for lawyers? Do we know any of? I have imposed on him in the past more than I should, so.
Your Honor, if I may, it would be suggested that Ms. Syke get reappointed the same attorney she had in general sessions, as there was a motion filed for a complex and extended case, as that attorney spent significant time researching this, and additionally, it's one of her pending motions that has not been heard yet. That is Ms. Syke's second attorney. She had hired her own private attorney at the beginning of it, and then got appointed an attorney once we had the initial first hearing. So it would be suggested that just due to judicial economy, that the same attorney be reappointed as she is familiar with this case.
Your Honor, sorry to interrupt. This is the case I discussed with you, and she is not available for appointment.
Motion for visitation as she promised. Judge Maxey was waiting for it. She told me just to go see my animals, which would be a trespassing charge. So she's trying to get me into trouble. Among with other things that she's done, she doesn't keep me informed. I never know what I'm coming to a hearing for. She doesn't call back. She's been ineffective. Give me advice to go see my animals, been a direct violation of law.
We have some.
All right, I'm gonna take a short recess so I can review this file because of the nature of these pending motions. We'll take a recess and I will come back to it. I do find this side has filed an affidavit indicating that her total income is $1,371 a month on disability. And for that reason, I find that she is indigent, and I will be appointing an attorney. It's just a question of who I appoint. When you have an attorney appointed for you, Ms. Sype, it is not always your option to decide that you don't like that attorney. You're always eligible to hire your own lawyer. But if we're appointing someone, then I will appoint someone that I think will do a good job, unless there's some ethical reason that lawyer cannot represent you, and then we'll go from there. I'm going to step off, and Mr. Vaughn, if you need to see me and shame me. All right. Rebecca Sipe. No. You have the key to this judge's office. Did you go get that file in this case? It's sitting on the judge. All right, based on my review of the situation, it's my opinion that the public defender's office does not have a verifiable conflict, at least in this court's opinion, that would prevent them from being able to take the case. And the public defender's office was commissioned by the state legislature to handle cases where criminal defendants are indigent, cannot afford an attorney of their own choosing. For that reason, I'm appointing Mr. Vaughn with the public defender's office to represent you, Ms. Sipe, and then with a, I think this was for arraignment as well, is that correct? We're going to give Mr. Vaughn a copy of the 17-count indictment. And copy of that's being handed, if you will, hand that to Mr. Vaughn.
Well, no, I'll see that, Judge.
All right. Plea of not guilty is entered, and because of the nature of this case and the statutory requirements, this court is required to set a hearing on the bond issue. And so that the record is clear, the bond issue is where the agency that removed the animals is requesting a bond to be posted by the owner of the animals to defray the cost of caring for those animals pending the outcome of the case. And if a bond cannot be posted, then the animals would be considered to be abandoned under the statute. We're going to have a hearing on that as whether or not that is the appropriate remedy. But we're going to have to give this public defender an opportunity to prepare. So on March 31st at 1 o'clock, we're going to have that hearing. Mr. Willoughby.
We just handed up a motion to correct the typo in the back of the indictment. The wrong name is listed. I don't believe Mr. Vaughn has.
No objection to that.
I thought I followed on the third, but.
And just for my clarification, is it my motion for bond or this?
The motion of bond by the ARC, Animal Rescue Corporation, that has been joined and consolidated with the criminal process. The civil case is also consolidated with this. Mr. Willoughby?
Yes, which I wouldn't have anything to do with. So.
Well, that's the whole point of what we're doing, but in this particular case, you're only on the criminal portion of it. So, Mr. Willoughby, I need to point something out to you.
Please.
What?
Read your next to the last sentence.
Your Honor, I'm confused.
Just a second. All right. Ms. Sipe, I have appointed the public defender's office to represent you on your criminal case. The motion to correct the indictment will be granted, and it corrects simply the name of the defendant on the back side of the indictment. I've appointed the public defender, as you requested, to represent you on the criminal case. The companion part of this case is the civil litigation that the Animal Rescue Corporation has filed, and it is civil in nature. You are not, under the law, entitled to have an attorney appointed to represent you on the civil action itself. Unless those two somehow coincide, then Mr. Vaughn's representation will be on the criminal matters. And if that coincides, then he can represent you to that whatever extent that he determines that his obligations as your criminal lawyer would involve. But there is a requirement under the statute that we conduct a hearing on the requirement of bond. So that hearing will be heard on March 31st at 1 o'clock.
Your Honor, the forfeiture bond was moved to the criminal side, so Lindsay York was taking care of both of them.
Yes, ma'am. And you didn't want Lindsay York. So I have
I don't need it.
Pardon?
Get anybody, because I can't do that by myself.
Well, that is the law in the state of Tennessee, that you're entitled to an appointed attorney to represent you. on a criminal matter, if by constitution you have the right to a criminal attorney, on a civil matter, which is the ARC's seizure of the animals and their bond request, that is not criminal in nature. That is civil in nature. And as a result, under the law, you do not have the right to have an attorney appointed for you in a civil matter. So we will conduct the hearing, and you, Mr. Vaughn, can be there at that point to assist you in any way that he feels that his office can do so without circumventing the limits of their representation. If you want to hire a lawyer on the civil matter, that is your choice.
I would rather have Lindsay back to have.
I understand that, but with what you said you wanted and what you said now that you wanted, you don't get to pick and choose, Ms. Seib. On just when I'm talking, it would be better if you would just stop talking. You don't get to pick and choose your lawyer when you're asking for appointed counsel. If you want Lindsay York to represent you, you can contact her and to make arrangements to hire her as your lawyer on the civil portion of this case, or the criminal case. But as far as appointing her, I'm of the opinion, and unless somebody shows me a law that I'm not aware of, that a civil litigation, is that correct? The ARCs?
Your Honor, a state versatility that does address whether the statute is criminal or civil. And the ruling on that was that this is a pre-judgment criminal matter. Now, there is not any clarification as far as if she is entitled to an attorney in that regard, but
Well,
there is.
it has been consolidated by an order of the General Sessions Court with the criminal case. So, Mr. Vaughn, you might want to look into that. But Mr. Vaughn will be here on the 31st. We will conduct that hearing, and your office will be entitled to determine whether or not you have one, a conflict at all, two, whether or not you can represent her on this bond requirement. So we'll have the hearing at 31st at 1 o'clock.
All right.
All right, thank you.
Your Honor, will we be able to present the?
Yes.
Your phone number, all right there. Just follow that.
All right, so we have Mr. Clark, what is the case that you're involved
Your Honor,
in?
this is State versus Alejandro Hermosillo. Mr. Hermosillo, you can come forward, please.
This is not on today's document, is that correct?
Correct, Your Honor. This is a case that's been pending in general sessions. We've agreed to bring this matter before the court, if the court will accept it today, by way of criminal information to enter a plea.
All right, what are we doing on criminal information?
Do you want to go ahead and swear on that?
Want me to recite the facts, Your Honor?
Yes.
State of Tennessee would prove that on or about July 29th, the defendant Alejandro Hermosillo, along with a co-defendant, were traveling through Ashland City and were pulled over for speeding. Upon a probable cause search of the vehicle, the officers did find mushrooms, a Schedule I drug with intent to sell, marijuana of not more than 10 pounds, numerous vapes and THC cartridges with the intent to sell, large amounts of drug paraphernalia to include trays, bags, digital scales, grinders, and a large amount of cash totaling over $3,000, along with a firearm in possession during the commission of this offense, Your Honor.
Right.
Okay, and Your Honor, the agreement, you want to go ahead and announce the plea now?
Yes, go ahead.
Sorry. Count one, Mr. Humphreys would be agreeing to plea to attempt to possess Schedule I for resale, Class C felony, be sentenced to 3 years suspended to state probation with a $2,000 fine. Count two, he would plead guilty to possession of a Schedule 6 for resale, Class E felony with 2 years suspended to state probation, concurrent with count one. Count three, he would plead guilty to attempt to possess a firearm during the commission of a dangerous felony, a Class E felony with a sentence of 2 years suspended to state probation. He would forfeit the weapon. Count three would be concurrent with counts 1 and 2. Count four, he would plead guilty to unlawful drug paraphernalia be sentenced to 11 months, 29 days, suspended to state probation, with a $150 fine. And count 4 would be consecutive to counts 1, 2, and 3.
All right. You want to hand up that document?
Yes, Your Honor. I didn't have probation.
All right, Mr. Hermosillo needs to come forward and raise his right hand. Raise your right hand and be placed under oath.
Yes.
Thank you. State your full name for the record.
So, yes, Your Honor. Oh, Alejandro Hermosillo.
Mr. Hermosillo, you're here today charged with a multi-count indictment. You've heard your lawyer go over what the indictment is. It's actually a criminal information. So I want to cover with you the rights that you have. Any person who is charged in a criminal case has the right for the grand jury of that county to determine whether or not there is sufficient probable cause for the matter to have charges formally brought into circuit court. You have the right to waive that step and have a criminal information indicating entered in this case. Is that what you wish to do?
Yes, Your Honor.
You talked this over with Mr. Clark, you and he discussed what the advantage to you is, and this is what you want to do. Is that
Yes,
correct?
Your Honor.
All right. Do you understand what you're charged with, and do you believe you and Mr. Clark have discussed it so that you fully understand what you're charged with and what the range of punishment you're facing is, as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want, is this a guilty plea? Do you understand if that you're going to be pleading guilty? Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, Your Honor.
Do you understand if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
Do you understand that if you went to trial, you and Mr. Clark could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, Your Honor.
Do you understand that if you would be presumed to be innocent at trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, Your Honor.
Do you understand if you went to trial, you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by entering this plea of guilty, you're waiving your right to that trial and to the appeal? All I'm going to do is approve what your lawyer's worked out.
Yes, Your Honor.
You understand that's going to result in some convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, Your Honor.
You understand everything I've explained to you?
Yes, Your
Do
Honor.
you want to waive your right to a trial and to an appeal by entering this plea of guilty?
Yes, Your Honor.
You understand if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we discover that you are lying under oath.
Yes, Your Honor.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that you are in fact guilty of this charge and that that there are facts to support it?
Yes, Your Honor.
Now, you've heard Mr. Hobson read the criminal information. Are all of those facts true and correct?
Yes, Your Honor.
You want to put any other facts, Mr. Hodlin, on the record? All right. Are you satisfied with your attorney services?
Yes, Your Honor.
Do you feel like Mr. Clark has done a good job of representing you competently?
Yes, Your Honor.
Mr. Clark, you know of any reason he should not enter this plea?
No, Your Honor.
Then Alejandro Hermosillo, on your plea of guilty to count 1, attempt to possess a Schedule 1 drug for resale, I'll find you guilty, sentence you to 3 years, Tennessee Department of Corrections, and we suspended the state probation. You're ordered to pay a $2,000 fine and cost. Count 2, found guilty, sentenced to 2 years, suspended to state probation. Count 3, you're found guilty of attempt to possess a firearm during a commission of a dangerous felony, sentenced to 2 years, Tennessee Department of Corrections, that will be suspended. A weapon is forfeited. Count 4, you're found guilty, sentenced to 11 months and 29 days in a county jail, ordered to pay a $150 fine. Count 4 is to run consecutively to counts 1, 2, and 3, and that will be for an effective 5-year sentence. And is that correct? 4 years.
3.
If it's consecutive, count 1 was 3-year sentence, count 2 was 2-year sentence, count 3 was a 2-year sentence. Count 4 is consecutive. Count 4 is the 1129. Okay, I'm sorry. That's right, a 4-year sentence.
And it's all probate.
All right, that's the judgment of the court. He needs to see the,
Thank you.
needs to see the probation department. We have some inmates here, I think.
Sign right here that you're waiving your right to go before a grand jury.
You have the criminal information of signing.
You've already waived that waiver. It's just. Thanks. Step up.
We have 2 female inmates. Let's bring up the first one. Maria Casso, is that correct? Maria Trinidad Casio.
I think that's Mario Cosio.
Oh, Mario.
I think this is Mr. Lockhart's.
All right, so who
case.
do we have?
One of them's mine.
Who, all right, bring her up. All right, I've been handed a document. This is Shelley Knowles in docket number 1979686. Ms. Knowles has been indicated that you're going to enter a plea of guilty to aggravated assault, receive a sentence of 4 years, Tennessee Department of Corrections, suspended and supervised probation. If you violate your terms of probation, it would be a 100% service, meaning you have to serve every day of that 4 years. That's only if you violate your probation and go to prison. You must also have and complete a mental health evaluation and follow the recommendations from that evaluation and have no contact with Brian Hollingsworth. Is that what everybody understands the agreement to be?
Yes, Your Honor.
All right, Ms. Knowles, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Shelley Jean Knowles.
Ms. Knowles, you've heard me go over what the agreement is, but have you seen or been shown a copy of the charges against you and gone over with Mr. Lockhart the range of punishment you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea to aggravated assault, then that would mean that the domestic assault is being dismissed. Is that correct? Count 2.
Yes, Your Honor.
All right. But do you understand you have a right to plead not guilty to all charges and to have a speedy and public trial by jury?
Yes, sir.
You understand you would have the right to have a lawyer and have one appointed if you could not afford for your own?
Yes, sir.
You understand that if you went to trial, you would have the right to plead not guilty and that you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes.
You understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine all witnesses the state called to testify against you. You could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand that you would be presumed to be innocent. You and your lawyer, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out with the state. You understand that?
Yes, sir.
You understand that's going to result in a conviction, and that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes.
You understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial and to an appeal by entering this plea of guilty?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes,
Anybody forcing you to do this
No,
against
sir.
your will? Do you understand if you plead guilty, the state or the court may ask you questions about the offense, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we find out you were lying under oath.
yes,
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
yes, sir.
And are you guilty of this aggravated assault? What did you do?
Yes, sir.
What'd you do?
What did I do?
Yes, ma'am. What did you do to commit an aggravated assault?
What did I do?
Yeah.
I put a knife to his private parts.
To-
Yes, because
put a knife
I
to-
did not.
this was someone you were
didn't want to no, I had not, I didn't want to consent to sex with him.
Okay, so you put a knife to this individual's private parts.
Yeah, I
Right.
told him to zip it.
Anything further from the state? Are you satisfied with your attorney services?
Yes, sir.
You believe Mr. Locker's done a good job of representing
Yes,
you
sir.
confidently? Mr. Locker, do you know of any reason she should not enter this plea?
I do not, Your Honor.
And Shelley Knowles in docket number 19786, upon your plea of guilty to aggravated assault, count 2 of domestic assault is dismissed as a part of the agreement. Court finds you guilty, sentences you to 4 years Tennessee Department of Corrections that will be suspended to supervised probation. And you, as stated, if you violate your probation and required to serve your time, it will be at 100% release eligibility. You must enroll in and complete a mental health evaluation and follow the treatment recommendations and have no contact with Brian Hollingsworth. She needs to see the probation.
Thank you, Your Honor.
Thank you.
Walk over there.
All right. Who's our next one?
Judge, I represent Ms. Clark. That is going to be for plea.
All right.
So she's pleading to count 3 and count 4. Counts 1 and 2 are going to be dismissed in settlement. Count 3, the especially aggravated sexual exploitation of a minor, it's a B felony. That'll be 10 years to serve in the TDOC, credit for time served. And count 4, solicitation of a minor, C felony. 6 years to serve in the TDOC. Concurrent with count 3, she'll have pretrial jail credits from 12/13/24 to 3/10/26.
All right, raise your right hand and let's place you under oath.
Yes.
State your full name for the record.
Melissa Jean Clark.
Ms. Clark, you've heard what your lawyer's gone over, but have you seen or been shown a copy of the charges so that you and he have discussed the range of punishment you're facing as well as any possible defenses you might have to the charges?
Yes.
Well, it's indicated that you want to enter a plea of no contest. What that simply means is that you're not going to admit you did anything wrong. But when the state tells me what their evidence would be at trial, you're not going to contest that. And as a result of that, I will use that evidence to find you guilty according to this agreement. Do you understand that?
Yes.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes.
Do you understand if you went to trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to that trial until the appeal? All I'm going to do is approve what your lawyers worked out.
Yes.
Do you understand that that's going to result in convictions that will be on your record in the future to make sure that, or make more serious the crime, the punishment you'll receive if you ever get convicted of a crime?
Yes.
You understand that this is going to require you to serve a sentence in prison, and that is a 100% service, meaning that you will be required to serve 100% of this?
Well, it is 100%. She asked me if it was 85. I believe you get up to 15% pre-trial.
Right, and she does get pretrial jail sentence. All right. And I believe it's more than, right at 18 months or more that she gets credit for. Do you understand everything I've explained to you?
Yes,
Do you wish to waive your right to a trial by entering this plea of guilty?
yes,
I'm sorry, plea of no contest. Is your decision to plead no contest today voluntary?
yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial. You may want to put your microphone over there toward you or come to the podium. But
You ready, Your Honor?
you're ready.
Yes, Your Honor, in docket 19695 on September 9th of 2024, a minor victim who would be the biological daughter of the defendant came in for a forensic interview. She stated that she was laying in the bed with her mother, who was communicating with someone that they only knew as Boatman, and he had offered to give them money to film a video of the defendant and her biological daughter using a spatula to penetrate her vagina, meaning the victim penetrated the defendant's vagina with the spatula. This was recorded on Snapchat and sent to this Boatman individual, and she did believe that her mother did receive cash because they were behind on a phone bill. We do not have the actual video of the incident, but there is a recovered video wherein the minor victim and the defendant are discussing who's going to do what to who and why. And when the defendant sees that she's recording, it stops. Those would be the facts.
All right, Ms. Clark, I'm not asking that you agree with those facts, but you understand this, what the state's evidence would be if this case went to trial.
Yes.
You satisfied with your attorney services?
Can I get that repeated? I didn't
Pardon?
hear you. I didn't hear you.
I'm sorry. Are you satisfied with your attorney services?
Yes.
You feel like Mr. Bond has done a good job of representing you
Yes.
competently? Mr. Bond, do you know of any reason she should not enter this plea?
No.
Anything further from the state?
No, Your Honor.
Then Melissa Clark, in docket number 19695, upon your plea of guilty to, or plea of no contest, rather, to count 3, sexual exploitation of a minor, especially aggravated, I find you guilty, sentence you to 10 years in the Tennessee Department of Corrections. You'll be given credit for time served. Count 4, solicitation of a minor, you're sentenced to 6 years in Tennessee Department of Corrections. That will be concurrent with count 3 as well. She gets pre-sentence jail credits as set out on this document.
Thank you, Judge.
Mr. Fuso, what do you have?
Good morning, Judge. I represented Mr. Roy Mayo. He's at page 6 of your Honor's docket. There's 2 cases, 2023 CR 19423 and 19424. This is a matter we've rolled a couple times. Mr. Mayo's in custody. We have obtained the expert, Your Honor, approved for that, and we've had him review everything. We're still talking about that, but we finally, I feel like at least have made some headway with trying to resolve the case. And I've got some authority from my client for the first time, and we're asking the court to potentially allow us to move this one more time to either plea or set it. I know Your Honor's position when it comes to setting a case for trial, and so if Your Honor would allow it, again.
Just don't want to set it for trial if it's not going to go to trial. So are we talking about July 14th?
I think that would be best, and I don't think we'll need a trial date after having some discussions
I don't
today.
think so either, Your Honor.
All right, July 14th.
Thank you, Judge.
So we will not need Mr. Mayo brought from the jail, correct?
No, Your Honor. I met with him last night here at the jail, so I informed him what we'd be trying to do today.
All right,
Thank
thank you. State versus Timothy A. Baxter.
Judge, I represent Mr. Baxter. I'd say call that. He is here now. That needs a trial date. That needs a trial date.
All right, General Sylvia, what, does it matter what month? If you think it looks bad for you, you can imagine what it looks for me.
That's fair.
So is this a case that I need to hear? Or, I mean, I'm glad to give you a trial date for, if that's what I need to do.
Yes. Otherwise.
So we'll be looking, if it's not in July, then we're looking at November. Nope. November, that's right. Well, it's my wife's birthday, so I'm not available. 17th, 18th, 19th, and 20th are all trial dates.
I have a feeling this will probably be two. I think we can get it done in 2 days.
Right. So do you want to put it on the 17th and 18th? Do you want the 19th and 20th?
What day?
So the county judge trial, the next is the murder trial that I'm on. I think that's going to be the whole week, so I don't know if we've got to go into.
What about the 12th and 13th of November?
12th and 13th.
Fifth and 6th of November, is that still goes for, you know? So is that day? Good. All right, set the trial, the 12th and 13th of November. That means Mr. Baxter will go to trial or plead to the indictment, and go to sentencing. State versus Andrew E. Fox.
Judge, represent Mr. Fox. I've got, I will request another status date. He and I have gotten on the same page back again. We can just have a July date for a final plea date.
General, you have any opposition?
No, Your Honor.
July 14th will be the last status date. It will be set for trial. If it's not resolved by an agreement, it'll be set for trial at that time.
Fair enough, Judge. I'm gonna get your card.
State versus Jerry Wayne Moore. Okay. They're waiting for you to bring him up. We need Mr. Moore brought up.
I've got Mr. Krantz here, Judge. That's for a bond revocation hearing. Other than that, that's all I've got available.
All right, well, let's do the bond revocation hearing. Jonathan Krantz.
Sorry.
Subject Krantz. All right, this is the state's motion to revoke bond.
Yes, Your Honor.
You may call your first witness.
Call Miss Leslie Anderson with A2I bonding.
So come around, please, ma'am. Step up into the witness stand and raise your right hand.
I do. Can you state your name for the record?
Leslie Anderson,
And where are you employed?
A2I Monitoring.
What is A2I monitoring?
We are a GPS monitoring company and currently the monitoring company for Cheatham County.
Do you have a contract with a Jonathan Krantz?
We do.
All right. Can you tell me what Mr. Krantz is charged with?
Yes, he was charged with a domestic assault in order to serve on our GPS monitor on January 15th, 2025.
What court ordered him to wear that monitor?
Well, it's a condition of his bond, so
And do you remember which court?
it would have been Cheatham County General Sessions.
So General Sessions ordered him to wear that. And remind me of that date one more time.
January 15th, 2025.
Okay. So can you tell me what the obligations of Mr. Krantz is as someone being monitored by your company?
Yes. Any of the bond conditions that are outlined, obviously are a condition of his program, along with the payment of the GPS monitor, keeping his contact information up to date with us, including his information. The victim that's involved in this case, he would not have been allowed to be around that person and any of the addresses that they gave. Those are the basics.
Okay. So as far as those conditions, was he presented with a contract?
He was.
Did he sign that contract?
He did.
All right. Which of those conditions is he currently not in compliance with?
He is not paying his GPS monitoring fees as requested.
All right. What has your company done so far to make sure that he can be notified and make this right?
Mr. Krantz gets a weekly email and or text from us that gives him his weekly balance along with his overall outstanding balance.
So how long has it been that he has not been able to pay?
His last payment was on February 1st, 2026.
Okay. So did he make any statements regarding paying the monitor?
He is not.
Has he made any efforts to pay on the monitor?
Not since February 1st, 2026.
Okay. And is his address current?
Yes.
So he's still residing at the address that you have on file for him?
Correct.
What about his phone number? Is his phone number current?
Yes, I texted him and he responded today.
Okay. Has he had any other violations?
Not that I'm aware of.
And what is his current balance?
$1,305.92.
I have no other questions, Your Honor.
Well, you have any questions?
I do. Just a couple, ma'am. My name is Winston Devon. I represent Mr. Krantz. Do you have a copy of this contract?
I do.
May I see it? And what does Mr. Krantz's payment history look like?
I did bring his statement today. Early on in 2025, Mr. Krantz was making a weekly payment. So in the beginning, we made an agreement that he would pay $56 a week, each and every week. The email and text are sent out on Friday, and he has a link to pay at his pleasure. He was doing that pretty rarely. And then after that, he just kind of fell off to once a month, about $56 once a month.
Okay.
And that's how his balance has accrued to what it is today.
Is deviating from the weekly payment to a monthly payment.
Yeah.
And you say the agreement was $56 a week? Okay.
It's $8 a day for every day that they're on, so that's 56 a week.
Okay. That's all I have.
Redirect.
No, Your Honor.
Thank you, ma'am. You may step down. Sylvie, you have any other witnesses?
No, Your Honor.
All right. Do you have any other proof you wish to offer?
No, Your Honor.
Vaughn? Thank you. Raise your right hand and let's place you under oath.
You state your name and spell your last name for the record, sir.
Jonathan Kane Krantz, Krantz.
And Mr. Krantz, I just want to remind you just overall with the cases still pending, let's not discuss any matters of that, just strictly the ankle monitor you've got, okay? So you heard Ms. Anderson discuss that you all had gotten on a kind of a payment plan of $56 a week. Is that what you believe too?
Yes, sir.
And then this, and you've been successfully having it without violations, according to Ms. Anderson, for about over a year.
I've been on an ankle monitor since 2024.
Yep.
September 24. Yes, sir.
So, and there's not really been any other issues, as she said. And then she's indicated that you're now at a $56 a month. What is there a reason for that? Like, what's happened?
I lost everything I owned. I was kicked out of my house. Bank accounts drained.
And that was while you were incarcerated, correct?
That is correct.
And so how did you lose your home?
White collar crime. My house was broken into. Some paperwork was stolen, and they used it to put my house in their name.
All right. So where you live now?
Nowhere.
Nowhere?
Nowhere. No, sir. I have all my stuff in a garage, but I still wasn't able to move everything.
What do you do for work, Mr. Grant?
I'm a mechanic.
Okay. And how is business?
Considering my transmission went out right after I lost my house and truck and had to move, it's pretty rough, but I'm trying to do what I can.
Okay. And so how are you getting money? Just side jobs and that kind of
No, I
thing?
mean mechanicing.
Mechanicing?
Yes.
Okay. Any particular shop? Or you just
No,
out
sir, just mobile.
mobile showing
Yes.
up? Got it. Do you think you'll be able to catch back up on this relatively soon?
Yes, sir. It's just been real rough the past month. Like I said, I've got like 500 I can pound it right now, and then I should be able to get caught back up as long as nothing else, happens.
Okay. So you would make a $500 payment today?
I'll pay more than that if I have it.
Okay, I'll pass.
So you lost everything while you were incarcerated. What were the dates that you were incarcerated?
Ma'am, I couldn't honestly tell you. I don't remember. I don't. It's trying to think. I don't know. It would have been December of 2024, all of it. Some in February,
February of what year?
2025. That was that. That's in it. Yeah, that's when I lost it. Yeah, that's when I lost it. That was February 2025.
Okay. So you lost everything in February of 2025.
Yes, ma'am.
So do you live at 1001 Carl Perry Road?
No, ma'am.
Is that the address that you've given the monitoring company on your contract?
It is.
Is that the address that you've given the court?
Yes, ma'am.
But you don't live there?
No, ma'am.
And have you updated that?
I have no way to update it. I live in a truck.
Okay. And do you remember signing the contract to go on to the monitoring company? Go on to the monitor?
I believe it is. Yes, ma'am.
Okay. And was that following your incarceration? These
I
dates?
think it was before. I don't know.
Okay. So how were you able to make payments then?
Excuse me.
Well, we have a good payment history, and your testimony is that you lost everything while you were incarcerated. So how were you able to make payments all the way up until?
Because I had a home and I wasn't being forced to move, and my vehicle wasn't broken down, and everything could go wrong kind of went wrong.
Okay.
Yeah.
So I'm sorry, your testimony is kind of moving around on me. When did you become homeless? If you lost everything when you were incarcerated, but you were able to make payments for a year because you had a
I lost
home.
everything in February, and I was forced to move in, I believe, November.
November of 2025?
Yes.
Okay. So how were you able to make payments after November of 2025?
Because I still had some money.
Okay. And then how were you able to make bond?
I believe I was released without bond. I think it was my own signature.
Okay. So you had an OR bond.
I believe that's what they call it. Yes, ma'am.
And did you understand that it was going to be a requirement of your bond that you wear a monitor?
Yes. Yes, state law, I believe.
Okay. And you understood that you were going to have to make payments on that monitor?
Yes, ma'am.
And what was your understanding if you were unable to make payments?
I wasn't ever told.
Okay. So if If you understood that in order for you to be on bond, do you know what bond is?
Yes, but, I mean, yeah,
What is bond?
not in jail,
Not in jail.
Mhm.
All right. And there's requirements to not be in jail.
I suppose.
All right. So if you're unable to meet a requirement to not be in jail,
Mhm.
what do you suppose the outcome of not meeting that is?
I mean, I guess it depends what the requirement is.
Okay. And if the requirement is to wear and pay for a monitor,
Well, you'd have to wear and pay for mine.
and if you couldn't wear and pay a monitor, what would you be doing?
Not wearing and paying them. I mean, I'd still be wearing it, but
Right. Would you be walking around or would you be required to go back to jail?
I do believe that depends on what county you're in, because multiple counties have determined that if the person does not have the ability to pay for the ankle monitor, that it comes out of general fund now.
Okay. When you signed an order agreeing to leave jail,
Yes,
did you agree to wear an ankle monitor?
I did not have a choice, but yes, ma'am, I did.
Okay. Well, the other choice was you could stay where?
Stay in jail.
All right. Okay. So we agreed, I'm not going to be in jail, but I'm going to wear an ankle monitor.
Yes.
And if you couldn't pay for the ankle monitor and you couldn't wear it, where did you think you would reside? Did you think you would go back to jail?
I was unaware that the payment part would send me back to jail, but
Okay.
yeah.
So there's all these conditions to be on bond and not be in jail, right?
I suppose, don't go anywhere she is and
Pay the ankle monitor, no new arrest, all those things you agreed to being on bond.
I believe, yes, ma'am.
Is this the only one that you think doesn't require you to go back to jail?
What do you mean? I didn't say anything doesn't require me to go back to jail. I'm unclear of the question.
Okay.
I'm
Did
just-
you, okay. What kind of things did you agree to when you made bond? What kind of behaviors and things did you agree to when you made bond?
Don't go anywhere that she may be.
Okay.
And I was not told where that is and went back to jail because of it. And, then, no illegal activity, I think, or whatever, just don't contact her.
Okay. And other things like, appear for
I mean,
court.
there was a page. Yes, ma'am. There was a
There's
page.
a whole
I-
page of
I
different
have no,
things.
all that stuff was stolen. I don't know. It was all thrown in a dumpster.
Okay, is this the only time you've ever made bond before in your life?
For this amount of time, yes, ma'am.
Okay. Have you ever had to go back for violating a bond condition before?
Yes, ma'am.
Okay,
Yes,
so you understand if you violate a bond condition, you go back to jail.
Yes.
All right,
Yes.
thank you.
Mr. Krantz, without asking you the details, you were arrested in this case, if I understand correctly, on September 8th of 2024 for
Yes.
aggravated domestic assault.
Yes.
And you made mention that you were on an OR bond, but the file here
Oh.
says you made a $30,000 bond through Pardue Bonding Company.
Yes, sir.
Right. And
February was the OR
That-
bond.
as of September the 8th of 2024, the bond conditions were that you must wear the GPS monitor. And that's since September the 8th of
Yes.
2024,
Yes, sir.
you were
Yes, sir.
supposed to do that. All right. And then I have another indictment, and I'm not asking you about the details, but it is true, is it not, that you were charged in a separate case with committing crimes of theft on or about the possession of a stolen motorcycle, and that is alleged to have occurred on January the 8th of 2025.
Yes, sir.
And that's still pending.
As far as I know, yes, sir. Yes.
All right. Thank you. Step down. Anything else?
No,
You wish to be heard at argument?
I'll leave it up to the court.
Mr. Ball?
Briefly, Your Honor, it doesn't surprise me that an individual that has the public defender's office has struggles with financial issues. It's pretty much the common theme of each individual I represent. I am familiar with Mr. Krantz's situation somewhat through our discussions as far as, the house situation. I'm aware of what he does for a living as far as doing mechanic work, and they're kind of being, somewhat seasonal kind of work. It's hard to do mobile mechanic in when it's freezing. I think that his history shows that there was an effort being made. I think that he was legitimately doing the best he could. He has stated that he has a chunk that he can get caught back up to where he, by my estimate, $600 or $700 short from fully caught up. We would just like maybe some time to make some arrangements for that and allow Mr. Krantz to stay out on bond so he's able to assist me in his case.
Your Honor, we heard testimony from Ms. Anderson. There's been multiple attempts to try to bring the account current. If Mr. Krantz had the ability to pay that money, he would have paid it by this time. This is kind of the last resort when it comes to payments, as well as Mr. Krantz understands the conditions of being on bond. And if you're unable to meet a condition of bond, it is likely that you would return to jail. He has been arrested on new charges. He has also, we've had issues getting in contact with him on this motion. I believe this is the third setting, so I would be concerned he's not keeping good contact with the courts and his attorney, which is also a condition of bond. Therefore, I would say that he has violated his bond in that he is unable to maintain this monitor. He's been given multiple efforts to be outside and on bail pending the resolution of his case, and he has failed multiple times.
I think it's important to be aware of the fact that GPS monitoring devices are not required in every case where a person is makes bond. So the reason why, and this court was inquiring into the court file as to why it was necessary to impose the GPS monitoring device. And I find the following was set forth in the affidavit of complaint that originated in this case back on May the 31st of 2024. On that date, it states that on September the 8th, 2024, at 15:33 hours, I, Deputy Sutton, was dispatched to twice daily on Jackson Phelps in reference to an possible attempted murder. On arrival, contact was made with the victim, Alexandria Smith. She stated that prior to calling dispatch, she was at 1001 Carl Perry Road, behind the residence, arguing with her ex-boyfriend, the defendant, Jonathan Krantz, about her owing him $800 and stealing his phone. Victim stated that while they were arguing, the defendant had what was described as a black AR-15 style weapon in his hand. She stated that she sat down on the ground and began crying due to fear of being hurt by the defendant, advising that he had hit her with the gun in the past. The victim stated that while she was sitting on the ground, the defendant shot the firearm into the ground near where she was sitting. She stated her eyes were closed from crying when he shot and was unsure how close the round came to her. She described her right ear hurting after the shot. And that was the offense that led to the domestic aggravated assault charge being brought. On September the 8th of 2024, when he was arrested, the bond was set at $30,000 with a hand notation by the Judicial Commissioner, must wear a GPS monitor. That bond was made by Purdue Bonding Company, and it was also indicated that he would be required to adhere to the GPS monitoring devices as well. In the file, there was a prior instance of him having his motion in General Sessions Court, a motion being filed to revoke his bond. If I recall reading it correctly, that in the General Sessions, they sought to revoke his bond because he was out on a bond for aggravated domestic assault and that he had been arrested for tampering with his GPS monitoring by removing said device from his ankle. And they sought his bond to be revoked at that point. Obviously, I assume that didn't result in a revocation. But more importantly than his non-payment of those offenses, which certainly clearly violates the requirement of the GPS monitoring device, is the fact that on or about January the 8th of 2025, while he was on bond for this case, he was arrested and charged with possession of stolen property, a motorcycle. And that case is still pending. He has a 2-count indictment charging him with 2 counts of theft of property. One was a black 2022 black QLC G50Z trailer, the other being a 2024 BMW S1R. And reading the affidavit, it does indicate that that he was found to be in possession of those vehicles. Pardon me. it came back stolen. Mr. Krantz, when those vehicles were checked, Mr. Krantz was in possession of the motorcycle. He admitted to borrowing the trailer, and when he got home, the motorcycle was inside. Anyway, the trailer was stolen out of Metro, and that was the reason that he was charged. So 4011-141 of the Tennessee Code states that subsection B, if after the defendant is released on personal recognizance on an unsecured personal appearance bond or other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of the orderly and expeditious progress of the trial or other proceedings, then the court may revoke and terminate the defendant's bond and order the defendant held without bail pending trial or without release during trial. This court is of the opinion that all of those provisions apply to Mr. Krantz. One, he violated the condition of release by not only not paying for the GPS monitoring, but having had a prior instance where he attempted to remove the device or had it removed. And secondly, he is in fact been charged with a new offense committed while he was released on this bond. And then thirdly, he engaged in conduct resulting in the obstruction of orderly progress of this case by failing to appear in court and failing to stay in the regular contact with his lawyer. For all of those reasons, the court finds that the bond should be revoked. Mr. Krantz is remanded to the custody of the Sheriff's Department pending trial. Mr. Krantz is in the custody of the Sheriff's Department. Go ahead and take up the inmates after Mr. Krantz is taken into custody. Mr. Krantz, you need to step back with the officer, please. Okay. We ready for any of the inmates? I'm ready to take up anybody that's ready.
Docket number 19733.
All right, Mr. Jerry Moore is charged with second-degree murder. Actually charged with 2 counts, but I think what is the status?
Your Honor, we're going to be entering a no contest plea to an count 1 that's going to be amended to second-degree attempted second-degree murder, Class B felony. It's going to receive 8 years, split confinement, serve 1 year. He does have credit for time served. He has 278 days worth of credit. The sentence will be served at 85%. He is to stay away from the victim's family and the Dollar Generals in Cheatham County. And I do have his signature.
All right, Mr. Moore, raise your right hand. Let's place you under oath. Raise your right hand.
Yes, ma'am.
State your full name for the record.
Jerry Wayne Moore.
Mr. Moore, you're here today charged with 2 counts of second-degree murder involving the same individual under 2 different theories of responsibility. It's been indicated that you're going to be entering a plea of no contest to an amended charge of attempted second-degree murder and receive a sentence of 8 years with split confinement, as your lawyer has stated. Have you seen or been shown a copy of the charges against you? Talk them over with your lawyer and discuss with your lawyer the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of no contendere or no contest. That simply means you understand what the state's evidence is going to be. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial. And that evidence will be used by me to find you guilty according to this agreement. Do you understand all that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
Do you understand at trial you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
Do you understand if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading no contest, you are waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Do you understand that's going to result in a conviction, and that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest to this charge according to this agreement?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that you are guilty and there are facts to support it?
Yes, sir.
And I need you to listen as the state tells me what their evidence would be if this case went to trial.
Yes, Your Honor, docket 19733 on November 17th of 2022. Officers responded to 2621 Good Springs Road here in Ashland City, Tennessee, to a deceased person who turned out to be the victim in this case, a Terry Merritt Jr. Once the officers investigated, it was determined to be an overdose death. They did go through the victim's phone, found some contact with a female who said that her and the victim had went to purchase drugs from Mr. Moore. They spoke to him on speakerphone, and the purchase was for heroin, or what they thought was heroin. Once they went there, did get the drugs, and then brought him back home, and that's where the victim's father found him. Last saw him, I believe, at 5:30 in the morning, and found him unresponsive at home later on that afternoon. They did go and interview Mr. Moore. Mr. Moore did admit to knowing the victim as well as the female witness, and he did admit that, according to him, he had smoked methamphetamine with the victim, but he was pretty adamant about the fact that he had not sold him anything. So this is the negotiated plea. The victim's father is here, and he will at some point want to read a statement whenever the court's ready.
Mr. Moore, I'm not asking that you agree with those facts. Do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead this no contest to the amended charge?
Yes, sir.
You still wish to plead no contest?
Yes, sir.
All right. Are you satisfied with your attorney's services?
Yes, sir.
You believe your counsel has done a good job of representing you competently?
Yes, sir.
Do you know of any reason you should not enter this plea?
No, Your Honor.
All right. Then have a seat, Mr. Moore, if you will, and we're going to allow the victim's father to make the victim impact statement. You want to stand at the microphone there at the stand?
Thank you, Your Honor. I had to write it down, I forget. My son is Terry T. Merritt Jr. I am Terry Sr. I'm here with his mother, Vicky. She's back there. Not only did my 4 grandkids lose their dad, him and his mom are having a rough time without him. We love him dearly. Not only I lost my son, I lost my best friend. I don't know what's going to become from this today, but I hope it keeps somebody else from going through what this family is going through. Losing a child is the worst thing ever. Thank you, Your Honor.
Thank you. Mr. Moore, come back to the stand. All right. Mr. Moore, upon your plea of no contest to the amended charge of attempted second-degree murder, I find you guilty, sentence you to 8 years Tennessee Department of Corrections, and will be served as split confinement for service of 1 year pursuant to statute with credit for time served. And pursuant to State versus Hicks, this will be an 85% release eligibility. He is ordered to stay away from the victim's family and all Dollar General stores in the state of Tennessee and Cheatham County. This is a situation where obviously there's been a life lost, and Mr. Moore has stated in his statement with the law enforcement that he didn't sell the drugs. But unfortunately, you're lucky to be alive too, whether or not you realize that or not. You know, people who ingest drugs, substances into their body without knowing what's in it are playing Russian roulette. And too often, especially in Cheatham County, it seems, we have deaths from overdose. We had a case not too long ago in front of me in this court where a man and his wife, young couple here in Cheatham County, wanted to celebrate their anniversary. So she said, I'll get a bottle of wine. Why don't you find us some drugs? So they were going to go get some cocaine. The husband went to buy the cocaine, bought it from some guy, came back. They found her dead in the house and him dead in the driveway. Both of them overdosed from fentanyl because they bought a bad batch of drugs. And, you know, there's no reason for them to have died. In this case, Mr. Moore, you were there when this all took place, and therefore you have some responsibility as according to this agreement. I understand this is probably a best interest situation as well, but I'm just saying this, you got 8 years to serve, and you're going to be on probation. Next time you think about putting something in your body or helping somebody else get drugs to put in their body, you might think about the fact you don't know what you're doing, and you might as well put a gun to your head and pull the trigger, because that's about as dangerous as you can get. So, all right, that's the judgment of the court. He'll be required to see the probation department after he's released from jail.
Yes, sir. Thank you.
Mr. Krantz. You want to put him on the 31st and give him a status day thereafter?
Let's do that. That sounds smart. I will be here.
I will be here too.
He's not set, is he set for trial?
I don't, not,
I
no.
don't think so.
When was it?
Today, today was, I believe, final plea. He's from
We'll give
two.
him another final plea date of March 31st.
Thank you, Judge.
All right. What else do we need? They versus Michael Deshaun Holt Jr. Let's see, we have somebody else in custody. Who else do we have over there?
Mario Castillo. That is my final judgment.
All right.
Docket 19748 and 19803.
So this involves two cases, Judge. 19748. Mr. Cosio's. He's pleading no contest to count 3, ag assault, C felony. That's 6 years TDOC suspended to supervised probation after serving 6 months, credit for time served. He's been incarcerated since September 30th of 2025. And at today's date, it's my calculation that he's got 161 days out of 180, so he is close. And then in case number 19803, he is pleading to resisting arrest, 6 months concurrent. But of course, this time here is, you know, that.
All right. Mr. Castillo, raise your right hand.
I do.
State your full name for the record.
It's Mario Trinidad Castillo.
You are here today charged with several different offenses, but have you seen or been shown a copy of those charges, talked them over with your lawyer and discussed the range of punishments you're facing as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of no contest or nolo contendere. All that means is you understand what you're charged with. You understand what the state's evidence is. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial. And I will use that evidence to find you guilty according to this agreement. Do you understand that?
Yes, Your Honor.
You understand, however, that you have a right to plead not guilty to all charges and have a speedy and public trial by jury.
Yes, Your Honor.
You understand that if you went to trial, you would have the right to have an attorney and to have one appointed if you cannot afford one, and we've done that with a public defender.
Yes, Your Honor.
You understand at trial, you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
You understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, Your Honor.
You understand that if you went to trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, Your Honor.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, Your Honor.
But you understand that's going to result in 2 convictions, and those convictions are going to be on your record in the future to make more severe the punishments you receive if you're ever again convicted of a crime.
Yes, Your Honor.
You understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead no contest according to this agreement and waive your right to a trial and to an appeal?
I do. Yes, Your Honor.
Is your decision to plead no contest today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
No, Your Honor.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, Your Honor.
Then listen as the state tells me what their evidence would be if this case went to trial.
First, in docket 19748, officers responded on May the 20th, 2025 to 1100 Buckstorm Road here in Cheatham County, Tennessee, to report of shots fired. Once the investigation was completed, it was determined that the neighbors and the victims of Mr. Cosio, the male, Mr. Wilson, had went over to his home to retrieve some tree straps. He thought he had permission to be on the property. Mr. Cosio, if he had permission, he didn't that day, and he asked him to leave. As he was leaving, Mr. Wilson would testify that he fired 3 shots as he was walking away. When officers arrived and Mirandized Mr. Cosio, he did admit to shooting him, but he claimed that Mr. Wilson had a machete or some sort of weapon on his person. Those would be the facts in 19748. In 19803, on the date listed in the indictment, while this case was pending, Mr. Cosio went to the Cheatham County Sheriff's Office. He was demanding or seeking to get some videos and body camera from the May 20th incident. And when they told him and explained to him that his Freedom of Information request did not include pending investigations, he became irate, started cursing at them. They asked him to leave the property or at least the room. They did get him out of the front office. And when he was outside, continued to yell. And I believe Lieutenant Dunning would state that he hit the door, and at that point, he was placed under arrest for disorderly conduct, and he resisted that arrest.
I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be at trial?
Yes, Your Honor.
Are you satisfied with your attorney services?
Yes, Your Honor.
I feel like that Mr. Vaughn has done a good job of representing you confidently.
Yes, Your Honor.
Mr. Vaughn, you know of any reason you should not enter this plea?
Can you repeat that?
I'm asking Mr. Vaughn if he knows of any reason you should not enter this plea. Then Mario Casio in docket number 19748, upon your plea of no contest, I find you guilty of aggravated assault. Sent you to 6 years Tennessee Department of Corrections that will be suspended to supervised probation after you serve 6 months with credit for time served. You're to have no contact with the victim and pay $60 restitution to the victim. Docket number 19803, you're found guilty of resisting arrest, sentenced to 6 months in the county jail with credit for time served, and all of the counts and all of their indictments are dismissed as a part of this agreement. Thank you.
I will say, just to reiterate this, Your Honor, I don't know if the Wilsons still live next door, but any hint I get of contact, we'll get a violation warrant, and Mr. Cosio will hopefully be right back. where he
Obviously,
is now.
that's part of the agreement on the suspended sentence is to be no contact with the victim, so you need to be very careful about that. So,
Yes, sir. Thank
all right, thank you. We have one more inmate.
Docket number 19628.
Judge, Mr. Haney is also mine. It's one of those that, was from the Ice Storm Times BOP day. I put him on today's docket. He's gonna admit that he's in violation, and be reinstated to probation with the credit for time he's been sitting and serving.
All right, so he's going to be admitting violation of probation to be reinstated to probation and anything else.
No, Judge, that's it.
Mr. Haney, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Michael Haney.
Mr. Haney, you're here charged with violation of probation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standards you had violated your probation?
Yes, sir.
You understand that you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea, you're waiving your right to that hearing and that appeal. All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, sir.
That's going to reinstate you to probation. You understand that?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to enter a plea of guilty according to this agreement?
Yes, sir.
And upon your plea of guilty, I find you guilty. I order that you be revoked to serve your sentence, but by agreement with the state and on time served, I will order that you be reinstated to probation. Thank you. You'll need to continue reporting to the probation office.
Thank you.
All right, thank you.
We still have Mr. Richardson, who's not appeared for his arraignment. He had called the court earlier today and said that he was sick. I also have filed a motion to revoke his bond. Reason being, and I know I heard the court say that if he comes in to wear a mask, Mr. Richardson's sick is not the catching kind. Mr. Richardson wears a scram device. He has had multiple alerts that he has a BAC, sometimes a
Benjamin Parker
0.24.
Richardson, are you ready then to proceed on that? Is he represented?
He is not represented and he hasn't appeared today. So I do know that his sickness may not be.
Conditional forfeiture of his bond, capious for his arrest.
Thank you, Your Honor.
All right. We know what. Well, we're gonna, doesn't matter. Be a citation for the bonding company issue, that and set it for the September date for final hearing. His new bond will be held for hearing. Anybody have anything else? Speak now or forever hold your peace.
I believe I do.
There's somebody in the back.
Yeah, I'm not who this guy.
Come on up. What happened to Mr. Takovas? Lucky him. Right up here. What's your name?
Jacoby.
Cody?
Jacoby. Quijada. Quijada.
Is that the one? Oh, we've got the 130.
Oh, is this the one I'm supposed to stay here for Marion? This is not Mr. Harrison. Oh, okay.
Jacoby, right?
Yes, ma'am.
No, that's not it. What we have at 1 o'clock, Mr. Vaughn, I think what we had was the Harrison case that you're standing in for, Miss.
I haven't heard anything from Marion.
But it was, you understood what the agreement was on the sentence?
I do.
And he's supposed to be here at 1. So
That's what I was told.
we will resume at 1 o'clock and hopefully have
be here for that, or can we just say?
I don't have a problem with you just announcing what the agreement is as to the sentence.
Okay.
Mr. Bond has some animals he needs to go kick someplace.
Yes.
Take care of the dogs, Judge.
Make sure there's no trespassers.
Yeah.
Keep the fortress safe. Release that.
We had a Michael Deshaun Holt that had a no answer also. It was for arraignment and evading arrest.
Yes, and I had filed to revoke his bond based on another arrest in Clarksville, but I obviously didn't serve that on his attorney yet because he didn't have one.
We have a $20,750 bond, be a conditional forfeiture of his bond. I'm gonna do a conditional forfeiture until we can get him in here to have that hearing. Conditional forfeiture of his bond, capious for his arrest. New bond will be set at $100,000.
I think he mostly hangs out in Clarksville, so I'll let the officers know.
But for, sorry, the final forfeiture will be set for that September date. All right, so that leaves us. Yes, it was just. A mess. We are recessed for lunch until 1 o'clock. It's my understanding you have an agreement.
Yes, Your Honor. I've spoken with, Ms. Fordyce. I know she's not here because of some personal reasons. I had the judgment sitting up there on your bench as well, but Mr. Harrison was found guilty, I believe, in count 3 of simple assault. The agreement is that he'll do 11 months and 29 days on probation, with the only condition being to stay away from the victims.
All right. Mr. Harrison, through your lawyer, it's been indicated that the state and you, through your lawyer, have agreed, instead of having a sentencing hearing where I would be the one to determine whether or not what sentence you would get and whether or not you would serve it or be placed on probation, they're agreeing to place you on probation for the length of your sentence. Are you in agreement with that?
Yes, sir.
All right, then I will approve that agreement and that will terminate your case. And you'll need to see the probation department here to my left.
Yes, sir.
Or to my right. Right, thank you. All right, that concludes our case for today, so we will end our